Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. It is snowing out. It is April 3rd, and I'm going to get between 6 inches and 3 feet of snow over the next 3 to 4 days. I love snow. I love New Hampshire. I do love it a little less in April. The snow, I mean, not New Hampshire. All right, we have a question here from YouTube user Good Deed Steve. It's a great username. How could I not do a good deed for Good Deed Steve? Good Deed Steve asks us, myself and a former coworker have cases with the Equal Employment Opportunity Commission against our last employer. He just settled his case and I haven't got a mediation date yet. Should I be concerned? Well, good deed, Steve. A couple of questions right off the cuff. Is he represented? Well, you are not. Did he make a demand? Did you make a demand? When did you both make your demands? Have you had... You're waiting on your mediation date. Did he have his mediation date? Did he file before you? What's going on? Are your cases similar? Are they the same claims? Do they spring from the same facts, or are they completely unrelated? All of which would be useful to know here. And I'm not criticizing how you asked your question. I'm just saying we could give you a little bit more clarity if we knew that rundown. That being said, I'm going to assume a few things. I'm going to assume, because you feel like your case is related, it seems, that it is related. I'm going to assume it springs from the same facts. I'm going to assume that you filed generally around the same period of time. I'm also going to assume he was represented and you weren't. I'm only basing that on the fact that his case is resolved and yours is not. So there's a decent chance that he had representation and you might not have. Now, if that is true, we've stumbled upon the answer about why his case is settled and yours is not. The EEOC treats pro se litigants, pro se claimants, with a casual, well-meaning disregard. A lot of times I'll see a hearing or like an interview date for an EEOC pro se litigant who comes to hire us. And it'll be like 9 months out, 14 months out. I think I've seen recently like a 16-month out one, I want to believe. And then the person will hire us and the case is resolved in less than 2 months. I'm not saying you should hire an attorney just for that. I'm not saying you should hire us. I'm just saying that is something we see, right? Things move at a very different pace when you have representation in the EEOC than when you do not. That's just facts. Just is what it is. I'm not even saying it's necessarily the talent of the firms involved. The investigators just prefer cases with representation, as far as I can tell, and work on them more and probably view them as easier cases to get resolved because there's attorneys involved. And when they get cases resolved, it's good for their metrics. So they work on those cases. Now, that's why I think this might have happened, right? I think that's why his case might be resolved and yours is not. Now, there's also other things that could be going on. If you're both represented, it could just be that he made a demand and you didn't, right? Did your attorney not make a demand? Did you refuse to give your attorney a demand to make? You don't need a mediation to settle a case. You can settle a case on a phone call. You can settle a case on a text message if you really want. Certainly people do it all the time, right? Hey, that file, blah, 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 blah. I'm not going to give you $400K. That's fine, but I wouldn't take less than 280. Fine. You want to call it 280? Call it 3. Fine. I'm not going to say that happened this week, but something very similar may have happened last week, right? Like, it's just what it is. And you got to push. And listen, maybe that case was only worth 80 grand and you got your client 300 grand. Just in the hypothetical, like stuff happens. Defense attorneys, just like investigators, have to choose where to put their attention. And if they look at a case and the case looks good and they know you're a good firm, maybe that case is not the case they choose to fight or dig that deeply on, right? So these things happen. Now, if you are represented and the case settled for the other, the co-claimant, then I would urge your attorney to get a demand in right away. I would also urge your attorney to be asking questions. Reach out to co-claimant's counsel. Reach out to co-claimant if co-claimant is pro se, and find out what the demand was, find out what the claims were, find out what the case settled for, find out the specific terms of the settlement agreement. Like, there could be things hidden in there that you might not agree to, and you want to know about that in advance. And listen, if the pro se litigant, you sound like you're in good terms with this fella, but like, if you have a co-claimant who's pro se who doesn't want to cough up details, lean on your attorney. Be like, hey, that guy doesn't have representation. He's having a hard time with his settlement agreement. Maybe you review his settlement agreement and answer some questions free of charge, so we can get the information about the settlement agreement. And just have the attorney going in and be like, hey, I'll review this for you if I can share the contents of your settlement agreement with my client, because you have similar claims. And it makes sense for us to help each other and collaborate. And great. Does that cost your attorney a couple extra hours? Sure it does. But your attorney gets a fat percentage of whatever she or he might win for you, so I think it's worth their time, right? I think it's something maybe their duty of loyalty for you, to you, would encompass, right? Finding out what's on the table, at least so far, is valuable, even if it's something that you would never take, right? Like, maybe the co-claimant took 20 grand. You're like, I would never take 20 grand. I would never take 20 grand. I think my case is worth 250 grand. Okay. So it's important to know everything you can about that settlement for 20 grand. Why did it happen? Why did your co-claimant think it was a good deal? What did your co-claimant's attorney think or say? Well, like, is their perspective valuable to you? Does it inform your position? Or is it absurd? Did your co-claimant just not have representation, didn't know what she or he was doing? Did your co-claimant have representation who sold them out? Case flippers, just trying to get that 20 grand so they can make like 4 grand an hour on their percentage after working the case for about 2 hours, right? Is that possible? Yeah, of course. All of this is information you can find out. So while I will strenuously say to you, no, you should not be concerned in terms of having things take different schedules with EEOC matters. That's normal. There's a variety of reasons why that could be happening. You should not be concerned. You should not be bothered. You should be active. You should be staying busy. Your attorney should be staying busy. This is happening, and it is a font, a wealth of information for you. And it can benefit you a great deal, right? And there's a really good chance that co-claimant has executed a settlement agreement that means they're not going to be able to testify for you unless you subpoena them now. Great. That's okay. You can do that if you need to, right? Like, that's not a big deal. It's not a huge loss for you. Also not a major concern, but it's good for you to know, right? Like, if you call them up and you're like, hey, I need an affidavit from you, and they're like, no. They might just say no. They might not explain to you, hey, I can't, right? They might not think that they can. It's even possible the language of their settlement agreement would make them believe that they cannot. Well, they're not going to tell you necessarily, because they might be afraid of the language, that they need to be subpoenaed to testify for you. Good to know that now, right? Because you're just calling them up and be like, hey, I need an affidavit from you. I might need you to testify. And they're like, not going to do it. You might think they're not going to be helpful to you. You don't necessarily understand that they just don't know that there's ways around their settlement agreement that tells them they can't testify, right? It's called a subpoena. Your settlement agreement in any jurisdiction I'm aware of can't trump the courts. The courts can still make you come in and testify, right? You can't contract around the U.S. court system's procedures, most often, generally, right? Now, I feel like if I knew a little bit more, good deed Steve, I could tell you a little bit more. But you did leave things a little bit general here, so I kind of just spewed words and thoughts on the topic. I hope it was helpful. If it wasn't, you let me know. Give me a little more specificity. I'll give you a little bit more clarity. But if it was good, if it was helpful, if it gave you some of the answers you're looking for, like, subscribe, comment down below. Tell us all the things we would like to know. Share the channel so it can grow. Take care, good Steve, and we will be rooting for you with your case.